Hello everyone, this is Tom Fox and I'd like to welcome you to episode 217 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. Today I have with me from the United Kingdom, Jonathan Armstrong and Andre Baywater. They are with Cordery Firm in London, and we're here to visit about the first Deferred Prosecution Agreement entered into under the UK Bribery Act. Andre was actually in court this week when the court announced its ruling, and they're going to walk us through the facts of the case, the claims against the defendant, Standard Bank, and then we're going to go into some of the details in not only the DPA and the hearing. It's a very interesting podcast. It comes in at just under 27 minutes. I hope you enjoy it, and thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I'm extraordinarily pleased to have two of my colleagues from the United Kingdom on, Jonathan Armstrong and Andre Baywater. And we're not going to talk about the FCPA. We're going to talk about the UK Bribery Act and an event this week, which I think was very important and significant for the anti-corruption and anti-compliance world going forward. The first Deferred Prosecution Agreement publicly announced in the United Kingdom. So, gentlemen, welcome, and thank you for taking the time to visit with me today.
Thanks very much, Tom. Delighted. Our pleasure.
And Andre, for those who have listened to my podcast before, you are certainly well of Jonathan Armstrong, and he has visited with us a couple of times. Andre, this is his first time, and he was actually at court when they held the hearing. So I think we're going to get some very interesting perspectives. The documents are available online in a variety of sources, and I've taken the time to wade through them because they are voluminous. And if you're a U.S. FCPA compliance practitioner, that you will find they're much more detailed than what you're used to seeing in our DPAs here. So, gentlemen, with that, perhaps you could lay some background for us. Talk to us about Standard Bank, how they got into trouble, and what they did to get this, I think, just fabulous resolution.
Yeah, maybe I'll start, then Andre will tell us a bit about the hearing, if that's okay, Tom. So I agree with you. I agree with you that the documents are voluminous. I mean, obviously, when the DPA system came in the UK, a year and a half, almost 2 years ago, there was a conscious effort to have it similar but different from the US system. And one of the differences was it was perceived that sometimes deals were done behind closed doors with the US authorities. And given some litigation we'd had over the Innistrad case over here, the thoughts were that wouldn't wash with judges here and with public opinion. So as a result, one of the provisions in the DPA is that the DPA can be agreed provisionally between prosecutors and defence. They can then speak to a judge privately to see if he would, if you like, bless or endorse that agreement. But the hearing, which makes the DPA, must take place in open court before the judge. So that's one of the reasons why this volume of documents was produced, because the authorities by which the judge and the prosecutors have released almost the whole kit and caboodle. So the statement of facts, the Deferred Prosecution Agreement, and the judgment are all now in the public domain. And Andre, there is actually a provisional judgment from an earlier hearing as well.
Yes, that's right. Of course, none of us knew what the hearing was going to be like. Going to these sorts of things, you would normally expect something to be quite adversarial. But in fact, I would say it was very matter of fact and very declaratory. Because when you look at what a DPA is, in a way that makes sense, really. As Jonathan said, everything has to be made public. But it was really the SFO's day in court, far more than the other side. There was a little bit of intervention from time to time from the judge, who's a very, very senior judge, very well-known man in the UK, Mr. Brian Levison, who conducted a very famous inquiry a few years ago. So clearly they wanted someone very senior to make sure that absolutely everything was right on this. But as I say, he only made a few interventions. He wanted a few things clarified, a few things stressed. But basically it was the lawyer representing the Serious Fraud Office who went through the indictment, he went through key facts, and he spent basically a long time, almost 2 hours I would say, going through the facts of the case quite fast. This email was sent, this happened, and so on, without any intervention basically, as I say, except for the occasional one from the judge. And so that took all morning. The judge then said he was going to come back in the afternoon to make his approval. He wanted to be absolutely sure there were no further issues. He told us that there'd been an earlier hearing, which of course none of us knew until we got there, because of course that was in private when the SFO made the application. And then he said we came back after lunch, and it was all done in about 2 minutes. He just said, I approve, I agree with everything, does the other side agree? They said they did. And that was basically it, and he said he would make everything available immediately online. So that was the hearing. Jonathan, any kind of thoughts you've had on that?
Yeah, I mean, I think the statement of facts, you can see why it took a long time to read. It's sort of 55 pages long. And I wonder, Tom, if it's helpful just to summarise that.
Well, yeah, I would ask you to do that because, frankly, the conduct at issue I thought was pretty egregious. And then I'm going to follow up with the judge specifically noted, if not found, that the parent Standard Bank was not aware of the conduct at issue, and then ask you some questions about really how much does a compliance officer or how much does a corporate officer under the UK Bribery Act have to dig into the facts of a transaction. So maybe this would be a good point to kind of walk us through the facts.
Yeah, so in simple terms, what happened is Standard Bank PLC in London, which for simple terms maybe I'll call the London Bank, did a deal together with a Tanzanian sister company called Stanbic Bank Tanzania Limited. And effectively what happened, and I'm oversimplifying what, as I said, is a sort of 55-page statement of facts, but effectively the deal was introduced by the head of corporate and investment banking at the Tanzania branch, and it was a deal to effectively provide finance to the government for a commission to raise government finance. And initially, the deal didn't go through, and the deal then came back round again with a higher commission payment, the commission payment being paid to an entity in which a Tanzanian government official had shares.
And also there were members of I think it was the Tanzanian tax agency, the head of the tax agency. He was also in that consultancy.
And if I recall, also the person who actually made the decision on this financing was part of the Tanzanian entity who acted as the agent. Is that correct?
Yeah. So effectively what happened is that the government officials have got their hands in this, and in addition, the son of one of the officials involved is also in the deal team at the local bank. So
okay, let me stop you there because I think the three of us would agree that there's certainly red flags all over this.
Oh, absolutely.
Even if you don't find any corruption at this point, how did this agent then pass even the UK standard for know your customer or the equivalent of third-party due diligence?
Well, I mean, I think that is one of the unanswered questions. It seems that the local bank only did a due diligence check on the agent as if they were opening a bank account. And by the way, that's what they did do.
Yeah.
The commission was paid into the bank account with the local bank, for want of a better word, and only when that amount of money, so $6 million was removed in cash, did the bank's compliance system kick in. And we do perhaps give them some credit for that. It was the money laundering reporting system that kicked in and caused the first suspicion, wasn't it?
Yeah, something that came up in court, which isn't really in the documents, is that there was a history of anti-money laundering failure here. You can see it on the website. They got a very big fine for having, it's the same bank, for having completely failed in their procedures before. They introduced a new procedure, which was praised in court, and yet it didn't, as you say, Jonathan, it sort of caught them out at the end, but somewhere in the middle, clearly things were missing. So
their onboarding process of the agent, let's be generous and call them an agent, Tom, the onboarding process of the agent was less than robust. Let's put it that way, it's a British understatement. Less than robust. But
the holiday season.
But the AML process, to their credit, does seem to have worked, flagged the withdrawal of the cash as something that caused concern, and that's when the investigation really kicked in from the London bank.
Jonathan, if I could now take the facts that you've outlined and turn to the allegation or the violation of the Bribery Act that the bank agreed to, or at least the prosecution put forward, which was, as I understand it, failure to prevent bribery. Could you talk about that? Because that's something that's a little bit different than the FCPA, and how does that work specifically in this case?
Yeah, so the failure to prevent provision, so technically Section 7 of the 2010 Bribery Act, was the real, if you like, the sexy new thing when the 2010 Bribery Act came in 2011. Previously, obviously, we'd had anti-corruption statutes on the books for more than a century. But this new provision effectively is easier to prosecute. And I think it's no surprise that we're going to see, my suspicion is a lot of deferred prosecution agreements will be Section 7 cases rather than what you might call hardcore bribery, partly because it's easier to prosecute, easier to prove, but partly because I think it's easier to agree to as well for a corporation. Instead of them admitting to bribery themselves, they're saying that they failed to prevent it and they didn't have systems in place to prevent it. So basically, under the legislation, a corporation has to have adequate measures in place to guard against bribery. There is a long document from the Ministry of Justice. The Ministry of Justice, of course, is an executive agency. It's not the equivalent of the Department of Justice. MOJ isn't the prosecutor. But the MOJ have set out in a long document what adequate procedures look like. And if you drop below that bar that they've set, then you're potentially liable to the Section 7 offence. And here I think what effectively the London Bank, and bear in mind it's the London Bank that's entered into the DPA, not the local bank. The London Bank have effectively said, yeah, we associated with our local sister company and we didn't put adequate measures in place to ensure that the deals we did together weren't corrupt. So obviously they didn't do things like proper due diligence because the London Bank said we relied on our colleagues on the ground locally to do due diligence, and effectively they didn't supervise or have input into that process.
So if I could now turn to the penalty, the bank. So I'm reading from this. Paid a fine of, as I understand it, $16.8 million as a financial penalty.
Right.
There was compensation of, I assume this was some sort of profit disgorgement of $6 million plus 1.46 US.
The disgorgement was 8.4.
Okay.
And the compensation of $6 million is the commission, effectively, isn't it?
Yeah, that's right. 6 plus interest, so it's about 7 and a bit.
And there was two other components. One was a payment of cost of £330,000 to the SFO. Could you all explain, is that to compensate the SFO for out-of-pocket cost, attorney cost, or something else?
Basically, yes. That's right, for having to investigate the case, take the case to court. But that was actually lowered because initially they were going for more, and that's about $500,000 US. So I think they probably got quite lucky as well, the bank.
And the SFO were at pains to point out the fact that they didn't just rubber stamp the deal, that they had an input into things like search terms in the electronic exercise, that they interviewed witnesses and so on. So the SFO are keen to point out that they were an active player in the investigation as well.
And all that has to be paid within 7 days of the judgment.
And then, so does this mean that the SFO can self-fund itself through its investigations, or am I taking that as perhaps a step too far?
I mean, theoretically, if the SFO can get some sort of resolution like this in everything that they investigate, then that's a possibility. I mean, bear in mind that under our system, some of the payments are to are recompense to the Tanzanian government, and some of them are a financial penalty. The SFO doesn't see the financial penalty. That goes into Treasury funding. It may or may not be allocated out again for further investigations or whatever. The fine elements go into Treasury funding. My understanding, which I don't think is dealt with in the document, my understanding is that the costs are returned back to the SFO rather than going into central Treasury funding. So it might be that you can break even on these type of investigations, but I don't suspect we'll know that maybe even until the SFO's annual report is published, which would be next summer.
Next June, yeah.
But if it goes back into general funding, it's clear to me now that it's not a self-funding mechanism for the SFO. So that was really the question I had.
Yeah, and we don't know the answer to that yet, because, as I say, all of this is brand new, but the conventional wisdom, and I think the SFO's press release says that the money is going into central Treasury funds.
Now, there was also one other payment, actually two. One you mentioned was the payment to the Tanzanian government, but there was also a payment to the United States government through the Securities and Exchange Commission, and I think I saw that was a $4.2 million payment. And then there was an interesting also side note that the profit disgorgement of 8.4, the SEC credited that payment that was made to the UK government. Did I get that right?
Yeah, I mean, that's a bit that's slightly puzzling. I've had a look at the SEC's press release, and they seem to be saying in some respects that they didn't have jurisdiction to deal with a lot of this, and therefore the UK authorities had been the lead, but it is presented as a simultaneous settlement with the SEC as well, and the SFO also credits, so non-financially credits, thank, if you like, the MOJ and the SEC for cooperating with the investigation. But it'd take wiser brains than me, and I think that means you, Tom, to explain why the SEC somehow felt they did have jurisdiction and they didn't.
And it relates to, it says, separate related conduct as well.
I thought I had the answer to that question on the tip of my email, but it doesn't look like I still have it. But actually, there's a specific SEC provision that covers this. I have to say that I made the same question that you did, and I asked the font of all knowledge on law, the FCPA professor, and he cited the statutory provision to me, but unfortunately, I
wondered if it was something almost akin to false accounting rather than bribery. So almost like, their books and records weren't in order rather than for the act itself. But that might be my distant UK lawyer's supposition on what happens in the US.
Okay, here's the answer. The SEC claimed that Standard Bank failed to make certain disclosures in connection with the offering in violation of Section 17A of the 1933 Act, which prohibits fraud and misrepresentation in the offer or sale of securities.
Wow.
So it's essentially not disclosing, but certainly a very tenuous connection. Nevertheless, a penalty paid to the SEC, and I was very interested that the SEC in the cease and desist order gave credit for the profit disgorgement. So lots going on here. We have the two-part hearing, or the two-part two-step process, one with a private hearing and then one in the public hearing. We have this incredibly detailed statement of facts that I think is, from kind of my world as a guy who tries to take the lessons learned, this is just a fabulous teaching document for both anti-corruption and anti-money laundering. We have some very kind words and direct words from the court about the quality of the presentation to him, both the written submission and the oral presentations by the parties, that he actually, he went out of his way, I thought, to congratulate all of the parties. I would have to say, sitting over here in Houston, Texas, this looks like to me a huge win for the SFO. Any thoughts from where you guys sit?
I mean, I think that's right. I think when the power to do a DPA came in, it was not an ideal tool, I think, if you're the SFO. One of the worries, of course, is this almost like a lack of discount for coming to see the government early. And that seems to me to be a hallmark of US DPAs. But here you really only get the same credit as if you were at the doors of the court for a trial and you pleaded guilty then. I think in some respects, this case is somewhat unique in that my reading between the lines is that there was a corporate transaction going on for the London bank, and it seems that the vendor of the London bank has paid the settlement. So in some respects, for the acquiring bank, it's sensible because it allows them to start with a clean sheet. And for the seller of the bank, it also sort of contains their liability, if you like, rather than having a long-running, warranties. They've sort of crystallized their payment, aside, of course, from the monitorship, which would be something I'd be interested in your views on, Tom, in that it's a 3-year monitorship. My suspicion was that in the US, some of the DPAs we'd seen were moving away from monitorships and or doing them over a shorter term. Is my read of that correct, or are 3-year terms still the norm in the US?
I would say that the Department of Justice has moved away from that as their pro forma response. What they would tell you is when they have a high degree of confidence that the company will implement the terms of the deferred prosecution agreement, a monitorship is not utilized. When they don't have that high degree of confidence, then they will put a monitor in place. But they are also significantly, or at least several times, have cut the monitorships from 36 months to 18 months based upon the good conduct of the company. So the effect is that it's cut the length of the monitorship term quite a bit, but it's now the exception to require a monitor as opposed to the way it sort of was several years ago.
Yeah. As opposed to the UK, where 100% of DPAs have had a monitor.
Well, gentlemen, this has been a very interesting podcast. I really appreciate you all taking the time to visit with us just soon after this event. I think we all have lots to chew on, both from the underlying facts, which I just can't get over the statement of facts, how detailed it is, and really what a great lesson tool.
Can I just add, Tom, that the judge pointed out himself that all we've seen is the abridged version as well.
Oh, my gosh. But let me end with, I didn't realize, and this is my fault, that Judge Levinson was on the bench. So could perhaps you tell my U.S. listeners who he is, what the commission he led was, and why it's so noteworthy in the United Kingdom?
Yes, I guess we should probably call him the Right Honourable Sir Brian Leveson. He's the president of the Queen's Bench Division, so the part of the court who hear cases like this. But he's also famous for doing a long-running inquiry into the hacking scandal and the conduct of the media in the UK. So he had such witnesses as Hugh Grant and Steve Coogan the last time he was live on TV. So he's a well-known judge, a well-respected judge, I think, in the UK. And I think Andre is right that we knew that it was likely that the first DPA would be put to somebody special. DPAs are reserved to a certain list of judges, and I think what the judge said in this case, from what you were saying, Andre, is he definitely wanted this to be a hallmark for how the prosecution and the defence would behave going forward.
That's right. Those were his final words, basically. That's the template for the future.
Well, it's a great start out of the starting gate, and I think a very good template for everyone on both sides of the Atlantic to study and learn from. So with that, gentlemen, I greatly appreciate you taking the time to visit with me, and I look forward to continuing the conversation.
Thanks very much, Tom. Bye.
Thank you. Bye-bye.
Bye.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have 2 calls to action for you. If you have any questions, please email them to me. I'm developing my next mailbag episode, so I'd be happy to discuss any questions you might have on an upcoming podcast. And the second thing is, if you like this podcast, if you go to iTunes and rate it, I would greatly appreciate it. This is Tom Fox, and thank you very much for listening. I look forward to visiting with you again.